tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
I told you this man never takes a holiday. David Whiting, Melbourne solicitor, is here with you to dispense free legal advice, and I've got some free lines. So please call if there's a legal problem bothering you. If you don't have the money to actually engage a lawyer, I've got one of the best in the business sitting here, and it doesn't cost a thing. 1300 222 774 is a number. Grab those lines before they fill up. They always do. And when they're gone, they're gone. We only have 25 minutes in which to do this, and he's got the expertise to offer. Good morning, David Whiting.
Good morning, Virginia.
I think Australia Day became a thing after you started working for yourself. Therefore, It's not in your DNA to take a holiday anyway.
Well, I was listening to Breakfast with Sammy this morning, and Australia Day only became a national holiday in 1994.
That's right.
By that stage, I was an employer, not an employee, so it didn't mean vast things to me. So, mind you, I've become. I was listening to RAF on Friday afternoon, and I got the comment about the day that we celebrate is the day of an invasion. So it's
we celebrate the day of colonisation.
Yes. Well, sorry, let's call it the introduction of European civilisation.
That's right. Yeah.
And
settlement, European settlement.
So it will be based on. I don't know. My current thinking is I would change. I still want an Australia Day. The question is the 26th of January the right one?
Discussions would be endless about which particular day, but there'll be one somewhere, I'm sure. Who knows if it changes? It's clearly going to take a number of years if it ever does. In the meantime, on this Australia Day, we've got some free legal advice to dispense. 1300 222 774. Marie is first up. She's first on the line out of Bendigo. Good morning, Marie.
Good morning. Good morning, David. Just a question. Being told by many lawyers in regards to her estate, the lady who's now deceased, she was a person that had life interest of her deceased husband's estate of 40 years.
Yes.
So she had a gracious life, lived to nearly 100, and passed away. So in dispersing her estate, of course, you have everyone come out of the hidden closets wanting their handout.
Yes.
But there's debts to be paid of her deceased husband's estate, which she had control of, being life interest. Now, we've got lawyers saying, oh, no, we're not going to be dispersing those monies because it's statutory barred, it's over 7 years. Sadly, the people that lent the money to do with probate back in 1975 have been told now, oh no, you can't get your money if you paid a probate debt.
Then you need
and there
to
was
look.
interest agreed on.
You need to look at some other parts of the Limitation of Actions Act. And what you have is a situation where so what we have, Virginia, is husband died, wife is the executor of the estate and the life tenant, which means she got to live in the house. She's now died, and the question now becomes what about the debts of the estate? There is a provision in the Limitation of Actions Act that talks about a situation for a trustee. So I would have said that the liability still exists, and it still exists against the estate, and you either need to make an application for a replacement trustee, or if the life tenant has an executor, the executor becomes the executor of the estate. So I say it's still a valid claim, but you need to look not at the first few sections of the Limitation of Actions Act, which talks about a period of about 6 years. You need to look at the back, which talks about whether there's a trustee in possession.
Yep. Okay. Thank you very much.
Thank
Marie,
you.
thanks so much for calling in. Lucy in Sunshine, how can we help?
Yes. I've got a family court order in place for my son. It's over 10 years now, and my son is 14. And we come to terms with his father.
Lucy, could I? Are you on speaker? Could I get you to pick up the phone and actually speak to us rather than be on speaker?
Okay.
It's very hard to hear you.
Okay.
Lucy, I'm going to pop you on hold. We'll come back to you. I'll get you to sort out your phone. We need you to be nice and clear and close to the phone. We're not an amphitheatre here. Graham in South Melbourne, good morning.
Good morning.
Go ahead.
We have a problem that Port Phillip we play Trugo in South Melbourne, and we have 3 different sections of Port Phillip. There's Garden City and Port Melbourne. We have been told yesterday that we are not allowed to play any more than on Thursdays, and we normally practice on Tuesdays, and just
Can I just jump in there? Do you play Trugo near the light rail line in Port Melbourne sometimes?
yes, that's possibly so.
I think I've seen you guys. Go on. Yes.
And the council have decided to stop us from playing, and we want access to the building on Tuesdays. And
So, Graham, is it not a competition between various groups who want access to council facilities, and it therefore becomes a question of, well, how do we prioritise, how do we balance the needs of various sectors of the community? Because they wouldn't be just saying, no, you can't practice because we want to close the building.
Well, for the last 9 months, they've closed the building altogether. They've stopped us from playing, and
I thought you played Trugo outside, not inside.
yes, outside. And they won't allow us access to go into the building and use the toilets and stuff like that. We play on the ground
Yes.
outside, and we've been playing there for many years in South Melbourne, but we also played at different places. Yarraville was generous enough to allow us
I think, Graham, it's really a discussion with council about priority for council resources, rather than I don't see that you would have a legal right to insist upon playing your game on someone else's property.
Well, it's more to get access to the building to use the toilet facilities, is it? Is that what it's about?
That's the main part about it, but the ground itself, it belongs to Parks and Gardens, and we use that. And
So you want both. You want access to the Parks and Gardens to play, but then some access to the building as well. So is there a legal?
It's not a legal issue. I would ring your local councillor and say, well, what's the issue? Why can't we? What are the priorities?
To FA.
It's very unlikely that your council will have told you. Council all will have told you that. You really need someone to advocate for you. And my suggestion in terms of the advocation would be to see if you can get a meeting with council as to what the issues are and what the priorities for the building are and how there might be a compromise that can be reached.
And whether there might be some safety or security issue around that building that they want to get perhaps even after hours or different hours access to. Graham, good luck. I hope that's helpful to you. Tim's in Coburg. Hi, Tim.
Oh, good morning, David and Virginia.
Morning.
Tim.
My daughter got her knees stuck in the gutter of an Olympic swimming pool just prior to Christmas.
Yes.
And we could not get the knee out, and it involved getting the fire department down to cut the gutter out of the Olympic pool to remove her knee.
How's her knee?
Well, she'll wear a scar for the rest of her life. She received quite a nasty cut on the inside of her knee, which required stitches, and this is the issue. The pool rang an ambulance while we were there, and off we went in the ambulance to the Children's Hospital, and all was well and good. About a month later, I received a bill for the ambulance ride.
How much was it? About $1,000?
Yeah, it's about $1,300 all told, which fantastic service, no problem with the bill. But I sort of looked at it and thought, well, surely this is the responsibility.
I think the legislation passes the responsibility to the person who uses the service.
Okay.
So if the pool, the municipal pool, called the ambulance and their services were not required, I think they don't get paid, right?
Yep.
So if you say, no, don't look at me, no, don't do any of those things, then the answer would be they don't get paid. My question really is whether or not it's a Tim responsibility or an underage child responsibility. I think it will be the underage child, but I'll just confirm. All right? It may also be that you agreed to them providing a service to your daughter.
Well, there's no conversation. I was sort of hanging on the side of a pool holding a child half out of the pool for an hour.
Yes.
And then all of these emergency service workers just materialised around me.
Well, Tim, isn't taking the pool out of it for a moment, isn't that something you would have wanted to have happened for your daughter?
Yes.
Wouldn't you, putting the
have
pool to
no
one
issue.
side, you would have called for that kind of help anyway, wouldn't you?
Absolutely, yeah. And look, it's covered by my health insurance. That's the payment of it's not the issue. I was just, they rubbed me up the wrong way with their dealing with the situation. I'm just I've been left sort of scratching my head thinking, well, I would have thought that the organisation would have jumped all over this to deal with it, and that's not happening.
No, the Act imposes the obligation on the person who gets the service.
But the question arises about whether, Tim, are you thinking about taking some legal action against the pool because of the accident?
Well, I wasn't at all.
No.
I just sort of thought, say la vie, this is the thing that happened.
You would also, if you think about the extent of the injuries that your daughter has suffered, you're unlikely to be able to make a claim.
Okay, well, that's a good thing to put paid to as well. So, but in any case, the bill rests with that family.
Yes, and but which just simply goes to the advantage of being a subscriber for $80 a year type stuff rather than getting a $1,300 bill.
Well, which Tim is, he says insurance covers it anyway.
Yes.
So he's fine. Tony in Keilor East, good morning.
Morning, how are you?
I'm well, thank you.
That's good. Look, I just had a quick question. I just wanted to know, recently a parent passed away. Just wanted to understand, just from an issue with, there was a borrowings on my parents' place and there's a title and the banks obviously hold the title. Do we have to do probate to get the title transferred to the surviving party?
If there are two people or multiple people owning a property, they can either own it as joint tenants or tenants in common.
Right.
If they are joint tenants, then you lodge what's called a survivorship application. You will need the bank's consent and approval, and the process is pretty much automatic. Right?
Okay.
If you own as tenants in common, then the interest of the person who dies goes in accordance with their will. That may be to the surviving partner and may not be, but you will need a grant of probate. And it's quite likely at that point that the bank would then talk about, well, now I need to get my mortgage discharged or the property refinanced.
Yeah.
Right?
Okay.
Because there's you will find that there's an issue with the amount of security that the bank now holds. So you will need, if they are tenants in common, then you will need probate. If they are not tenants in common but are joint tenants, you will not need probate.
All right, and I can check that by searching on the titles office.
By having a look at the title, yes.
Yeah. Okay, thanks for your help today.
No worries. I'm glad we could be useful. The number is 1300 222 774. David Whiting is here dispensing his free legal advice. Henry in Mulgrave has a noise problem. Hi, Henry.
Hello.
Hi, Henry.
Go ahead.
Yes, I've had a problem with a neighbour's very noisy air conditioner for many years, and I've complained to the council, and they've come out 3 times to inspect the situation, but they've taken no action. Now I'm going to sue them in the magistrate's court, and I wanted to know, to whom should I make the complaint, the council or the particular officer who came out to do the measurements?
So I'm trying to work out, why is your claim not against the person who owns the noisy air conditioner?
Well, because I don't want to aggravate him.
Well, but if we look, so you're going to take the council to the magistrate's court because you don't think they've done what they're required by law to do?
Yes, that's right.
I think your claim would be against the council because they would be responsible for the actions of their employee. But what you would need to prove, Henry, is that they had a positive obligation to act in your cause. But even if that was the case, they can still have a further discretion as to whether they do anything about it or not. I mean, what you're really doing is saying, I want the council to do something I might be able to do myself, and that strikes me as fairly unfair on council.
So you've actually just got to have the tough conversation here.
Yeah. So I would be saying to the council, why didn't you take an action against the man with the air conditioner? But the law also gives you a right, Henry. You could have a go at the neighbour with the noisy air conditioner.
But the neighbour is sort of quite aggressive.
So, but let's put it slightly differently. Do you think that if the neighbour ever found out that the complaint was because they would be measuring the noise from your property, why would it not, I would suggest to you that the neighbour will know that you were the cause of the complaint and might be equally upset rather with whether you were the person who issued the proceeding or not. So I think you really need to look and try and solve the fundamental problem, and the fundamental problem is the noise from the air conditioner, not council's failure to act as you want them to.
We wish you luck and hope that goes well. Ray is in Doncaster and has a particularly challenging problem here. Hi, Ray.
Good morning.
Hi.
Good morning. Go ahead.
Look, I've just recently, my wife had a fall in a supermarket last Friday. She had to step around a stock trolley and subsequently tripped over a trolley stand, and she broke her hip. Yeah, and she had a total hip replacement done on Saturday, which all went well. I spoke to the store manager yesterday wanting to get a copy of their incident report and the CCTV, and I got the answer which I was expecting, that they could not give that out. I'm just wondering, they just sort of sent me a form with their insurance claim policy and stuff like that. Now, I just need to know, should I contact a lawyer or just trust the process?
You're going to need a lawyer, Ray.
Yep.
You're going to need a lawyer to be satisfied that the amount of compensation that your wife is entitled to is fair and reasonable.
Yep.
Or you could do it yourself, but in the circumstances, I wouldn't.
Yep.
And you would probably I'd be keen to wait a little while to work out whether there are long-term issues.
Okay.
In a financial sense, you're probably between a rock and a hard place, because if you're in a situation where you're entitled to compensation from somebody else, there may be some issues in making a claim with your health fund or with Medicare.
Okay, well, we've got private health cover, and that's why we got the hip replacement done ASAP.
Yes.
And
you need to note that if you make a claim for compensation on the insurer will be entitled to recover the payments that they've made from whatever your payment is from the supermarket.
Okay.
Right.
Yep.
So you can't turn around and say, well, I needed a hip replacement, so my compensation level is $10,000, and by the way, someone else had to pay for the hip replacement. So
Yeah.
are you retired? Are you, Ray?
No. My wife and I both work, and she actually works in aged care, so she obviously can't do that for probably 2 or 3 months.
Yes.
But we also have our own business where she helps out with that as well.
So you need to work out what her total income loss is going to be.
Yep.
Unlikely to get a great amount for pain and suffering. And the only reason I would suggest that you even consider proceeding against the supermarket is because it's something that they positively did. We get lots of people who says, I fell over because there was a cordial bottle that broke, and don't do those. But this was there's a stock trolley, and you tripped because they didn't deal with it properly.
Oh, no, the supermarket were fantastic on the day and everything, and
Yep.
they rang me Friday afternoon. And the manager, when I spoke to him yesterday, he was more than helpful and everything. But yeah, I just didn't know.
Ray, that's what they have insurance for. So I would be going and I'd be getting some assistance.
Good luck, Ray.
Thank you.
Jenny in the Yarra Valley, what's happening there? Good morning.
Oh, good morning. My mother died in late August last year, and she left a lawyer as executor.
Yes.
And we're having a lot of frustration with him not getting back to us. He said the house was going to go on the market end of January, early Feb, but we haven't been able to get into the house to do any of the clearing up or sort out who's getting what items. What can I do? She just doesn't answer calls, doesn't answer emails.
That's not good.
I would suggest that there's an issue, Jenny, that needs to be worked out between you and the lawyer. And what you need to understand is that the lawyer is giving effect to the will the way it was drafted.
Yes, I have a copy of that.
Yeah,
yes.
he is not acting as your representative
Absolutely,
in
I
dealing with the
understand
estate.
Yes, I understand
So
that.
when you come along and say, I can't get access to the house to clean it up, You have no right or entitlement to do
I know.
that.
I understand.
And you're talking about giving away items, dividing up items in the house. You don't have the right to do that either.
No. Look, David, I understand all of that.
Yes.
I know that he has to be there at the house when we go through and look at different things. If we can't agree on who's getting what, he said, I'll just sell it. I understand all of that, but it's his non-communication with us. And how is the house going to go on the market in late January? Or
He's only got 2 days to go, yes?
Yeah, so, we're just stuck in limbo.
You would have this exactly the same issue, whatever the executor is. It would strike me that your real issue is a communication issue.
Yes.
And I would be perhaps asking for a timetable.
It's possible you also have a lawyer who's just not proceeding as expeditiously as they should.
Well, we have a concept
some
called...
Some are slower than others, David.
We have a concept called an executor's year, and you're really not in a position to complain much about what an executor's doing until 12 months after the death.
Yes.
Because, the law was developed at a time when there were probate forms and fees to be paid and duty and all the rest of it. So it was awfully complicated. It's now not nearly so complicated.
But they can nonetheless take that time.
They can take the time. I think they're being unreasonable.
He was the one who suggested that the house was going to go on the market January, early February.
Yes. Now, the other thing that I would be concerned about if I was the executor would be, I suppose what I would be looking at would be asking the executor to prepare a report on the administration of the estate on a monthly basis and to send it out. And that way to communicate equally with all beneficiaries in the same way.
And if that doesn't happen, where do you go and complain next?
Well, the answer is it's an application of the Supreme Court to remove the executor, and we're costing far more money than would be justified.
The moment you use the phrase
application
to the Supreme Court, I just glaze over. I'm like, nah.
Okay.
Well, I'm already 10,000 deep at least.
Easy. So Jenny, it would be, can we have a monthly report that you send out by email as to the administration of the estate, as to what you've done in the last month and what you're proposing to do in the next month?
Good luck, and we hope that goes well. I think we can just fit in Peter in Collingwood this morning. It might be relatively quickly dealt with. Peter, good morning.
Good morning, David and Virginia. What is the legal position when you have a booking at a hotel or restaurant and you arrive and you don't own a smartphone and they insist on you're using a smartphone and a QR code?
Oh, to check in to be COVID safe, you mean, for the contact tracing?
Yes, I had thought you were able to write down your name and phone number.
The regulations provide that they can use a QR code, but the expectation in the regulations is that there will be an alternate method, which is name and phone number.
Yep.
Oh, thank you very much.
So you're well within your right to say, I don't have a phone. Please hand me the form that you also have that I can fill in.
Oh, thank you very much for your help.
And when you do that, sanitise the pencil or use your own.
Of course.
Good on you. Thanks so much. Nicely done there, David.
Thank you very much.
We've decided we're going to nominate you for an Australia Day award.
Oh, no, there's lots more people need them more than I do.
No. This is all done out of your own time. It's volunteered. It's a great community service. How many years have you been doing it?
February 83.
Ho! Mate, you'll get an AC. We might even just, bump you right to the top of the list.
Not a hope. Thank you, Virginia.
Not a hope. Thank you so much. David's back next week. We won't be statewide next week. It's a shame, but you can always tune in via other listening methods and ask him a question as well.